Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation. We have picked up a couple of important articles from the Hindu, the Indian Express, Deccan Herald newspapers, which are very significant from your KAS examination point of view. What is that you have to do? If you're liking these initiatives, please hit on the like button, subscribe to our YouTube channel and also share it with your fellow aspirants as well. Let's look into the first practice question and the first article for the day. The first practice question says, with respect to Krishnaraja Wadeyar IV, which of the following statements are correct? He was the 25th and last ruling Maharaja of Mysore, reigning from 1940 to 1950. Maharaja of Mysore constructed the Krishnaraja Sagar Dam during the famine. He abolished child marriage, gave special importance for girls' education and offered scholarship for widowed women. He gave voting power for women for the first time. Which of the statements are correct? The answer to this is 2, 3 and 4. Why have we taken this practice question? Because this article on the Hindu makes a reference to Krishnaraja Sagar Dam, which is why we have taken this practice question. Let us try and understand what are these statements. When you look into the first statement, he was the 25th and the last ruling Maharaja of Mysore, reigning from 1940 to 1950. This happens to be a wrong statement. Why? Because he was not the last ruler of Mysore. What is that you have to do? Who was the last ruler of Mysore? Who was the 25th ruler of Mysore is what you have to put on the comment section. But one thing is for sure, that he wasn't the 25th and the last ruling Maharaja of Mysore. Who is it? Is what you have to put on the comment section. So the first statement is wrong. When you look into the second statement, Maharaja of Mysore constructed the Krishnaraja Sagar Dam during the famine. Yes, this statement is right. In fact, during the construction of this particular dam, it was opposed by the Madras presidency as well. When you look at how this Kaveri issue starts emanating every now and then, we also have to look into this particular parameter. This construction of the dam started back in the year 1911 and was ultimately concluded in the year 1924. Many people did oppose as well. Why? Because their lands could also be taken away. But all those people whose lands were taken away, about 10,000 people, they were provided rehabilitation. This rehabilitation was provided within the precincts of Mysore and they were also provided alternative agricultural lands. So the second statement which reads, Maharaja of Mysore constructed the Krishnaraja Sagar Dam during the famine. Yes, this statement is right. The third statement reads, he abolished child marriage, gave special importance for girls' education and offered scholarship for widowed women. Yes, this was one of the reformative steps that was taken by Krishnaraja Wadeyar IV. This statement is also right. And the fourth statement reads, he gave voting power for women for the first time. Yes, this statement is also right. That was the reformist nature of Krishnaraja Wadeyar IV. In fact, he also brought lot of reforms when it comes to the educational sector as well. For example, the Indian Institute of Science was given a lot of land. Tata Institutes were given a lot of land as well. Maharani colleges were started for the women. So for the purpose of education, large swathes of land were also given by Krishnaraja Wadeyar IV. So the first statement is wrong. The other three statements are right, which is why the answer to this would be 2, 3 and 4 only. Now let's look into the next practice question. Which of the following statements with respect to Bhadra Wildlife Sanctuary are correct? It is a protected area and tiger reserve as part of the Project Tiger, situated in Chikmagaluru district. Hebbegiri is the highest peak in the sanctuary. Most of the areas consist of wet deciduous forest, moist deciduous forest and green forest. Which of the statements given here with respect to Bhadra Wildlife Sanctuary are correct? The answer to this is 1, 2 and 3. All the three statements that are given here with respect to the Bhadra Wildlife Sanctuary is correct, which is it is in the district of Chikmagaluru district, it is in the state of Karnataka and it happens to be a protected area and a tiger reserve, and this happens to be the right statement. The second statement is that there is something called as the Hebbegiri peak, and this Hebbegiri peak is the highest peak in the sanctuary, that is in the Bhadra Wildlife Sanctuary. The highest peak happens to be Hebbegiri. The third happens to be most of the areas that is present within the precincts of this particular Bhadra wildlife sanctuary happens to be wet deciduous forest, moist deciduous forest as well as the green forest. So all the three statements that are given in this practice question happens to be the right statement. Why have we taken this practice question? Because this article on the Hindu makes a reference to Bhadra Wildlife Sanctuary. So the Bhadra Wildlife Sanctuary is in the Chikmagaluru district, and this happens to be the map of the Bhadra Wildlife Sanctuary. So notices have been issued to firms set to develop coffee estates near Bhadra Sanctuary. So because they could be diverting the lands, because they could be taking upon some of the areas of this wildlife sanctuary, they have not been allowed because it could possibly come under the buffer zones. So a notice has been issued that whatever development that you're planning to come up with within the precincts of this wildlife sanctuary should not be taken up, is what is this article all about. Now let's look into the next practice question and the article. Which of the following is correctly matched? What we have is a GI tag and the state that this GI tag has been given. Dongeria Kond, Odisha, Ramnagar Banta, Uttarakhand, Mausari, West Bengal. Which of them are correctly matched? The answer to this is one only. Why have we taken this practice question? Because this article on the Hindu makes a reference to the GI tags, which is why we have taken this practice question. Let us try and understand what are these statements. When you look into the first statement, it reads Dongaria Kond happens to be from the state of Odisha. Yes, this statement is right. So the first one is right. Ramnagar Banta happens to be from the state of Uttarakhand. No, this is wrong because this is from the state of Uttar Pradesh, and the third statement is also wrong. Mausari also happens to be from the state of Uttar Pradesh. So we have two statements that are made, which is from the state of Uttar Pradesh and which is the I. This answer happens to be one only, and the other two options are eliminated. So if you look into this article, it goes about speaking that there are a couple of GI tags which have been awarded to number of these products. Why is that? That is because it carries a regional legacy of its own and it also has regional importance of its own. When we speak about GI tags, what are these? These are nothing but the geographical indications. What are these geographical indications? These geographical indications are the products which have been accorded what is called as a geographical indication tag because it is grown in a specific region, because it has a unique attribute of its own, because if at all there are people who are manufacturing it, they manufacture it in a unique ways, and because it is restricted to a specific geographical region, it is provided with geographical indication tag. So if we look into the Dongoria Kond shawl, it happens to be from Odisha. Then we have Sundarban honey, which is from the state of West Bengal. So a GI tag is a sign used on the products that have a specific geographical origin and possess qualities of reputation that are due to the origin. That apart, we have the Nagpur oranges, which have also been given the GI tag. Then we have Tirupati ladus, which have also been given the GI tags, and then we also have Nagpur oranges. So there are a couple of things which are given. For example, we also have the Banarasi pan, which is also being given the GI tag. So kindly run through this article. You have couple of GI tags which are accorded. So you will understand which are the GI tags and which is the state that this GI tag has been accorded into. Now let's look into the next article. This article says curb the disillusionment with the traditional rule of law. What is this article speaking about? The article here is speaking about the traditional rule of law and the modern rule of law. It speaks about the authenticate traditional rule of law, the rule of law, the meaning of it, the very idea of it, the very significance of it, and also how laws have been changed over a period of time, which is actually not meeting the standards, the uniformity and the model laws that have been established. What are we understanding here? We are understanding that there is a meaning called as rule of law. What is this rule of law? Whenever you speak about a law, you have to understand for a fact that why did the law come into picture. For example, if we take the contract law in place, what is a contract? A contract is nothing but an agreement between two people where it also has the faith of law into picture. For example, let me explain in simplest of terms what is the difference between an agreement and a contract. What is an agreement? Let's say for example, your parent says that you would be, let's say you're working hard and you would ultimately become the first ranker in your school or the college. So the minute you are able to become the first ranker, or you're able to obtain, let's say about 85%, 95% in your schooling, I would gift you an Apple Watch. So this is an agreement. So what is an agreement? An agreement is wordings between two sets of people, and then ultimately you ensure that you work hard as well and you become the topper of the class, and you're also able to get 85% to 90%. But what does the dad say? The dad or your parent says that this was only to boost your morale so that you become the topper. I'm not gonna gift you an Apple Watch. So can it be enforced by law? No. So an agreement is between two people. But what is a contract? An agreement between two people which is enforceable by law is the contract. What if I have entered into an agreement with another person who happens to be a supplier of a product? So if at all this person is supplying a particular product for me and I have to give him a particular amount because he's supplying a product, this means we have entered into an agreement which is enforceable by law. If the other party does not meet up to the requirements as envisaged by the agreement between us, in that case it is violating the contract. So the very idea of coming up with a law is there would have been a loophole or an existential problem within that particular premise or a region, or for example a problem. So in order to ensure that this problem does also have a solution, there is a right which is getting violated. To ensure that the consequential benefits for this particular rights, in order to prevent that, what we have is laws that are created. Similarly, when we speak about criminal laws, what happens? There has been a social norm that you can do whatever you wish to do as long as you're not violating the rights of another section of the people. In order to ensure that all these rights are followed, what we have is the criminal law. Let's say for example, I go and hit another person. Am I violating the laws? Yes. Why? Because that is hurting another person. So criminal law comes into the picture. Let's say I'm snatching away the life of a person. There is murder of a person. That means you're violating the rights of that person as well as the members of his family. So this is where the criminal laws comes into the picture. So we have many other laws. There are loopholes that are existing in the system. In order to correct these loopholes that are existing in the system, we create a law, and that law can be in the form of different kinds of laws. So what does this article basically say? The article basically says that if at all a law is made and it is given a ratification by the government as well as by the parliament, it ultimately gets implemented. So all the laws that are right will have to be followed by the people of that particular region as well as the country, because it is the representatives who made the law, because it is the parliament which has made the law. If at all people have made the laws, these laws will have to be implemented and people have to follow these laws. But what if there is a law which is made by the parliament which is questionable in nature, which means that this very law at the very initiative also looks very bad as well. It also takes away or snatches away the rights of the people. In that particular case, this law can be questioned. For example, during the independence movement, we had the Dandi March. It happened to be a mass civil disobedience movement undertaken by Gandhi against the salt tax. So there was salt tax that was imposed on Indian people. In order to prevent it, Mahatma Gandhi ji organized the Dandi March. Similarly, right now, if there are certain laws that are passed, if these laws are snatching away some of the rights of the people, then you can go ahead and protest, says the author. For example, if we speak about the right to protest, it is also one of the fundamental rights as well. And at the same time, if people feel that farm laws were not doing justice, withdraw these farm laws, because that's your right. Right to protest is also a fundamental right guaranteed under Article 19 of the Indian Constitution, which is about freedom of speech and expression as well. So you feel a certain set of laws are not right, then you have to change it, then you have to request the government to do it. You can go ahead and protest in a peaceful manner, not raising the arms, taking up the arms against the government. So if at all there is a right law, good law, correct law, then you have to enforce it and people have to follow it. But if the law itself is questionable in that particular case, then you have to question the law as well. The government of India has come up with a couple of changes as well. Let's say for example, we have the Jan Vishwas Act of 2023. What are these? These are to do with the business laws. For example, there were a couple of businesses, there were a lot of license raj, permit raj. This ultimately meant that people were not able to conduct their business activities. In order to simplify this entire process of business, Jan Vishwas Amendment of Provision Act of 2023 was done, so that the license permit raj is completely eliminated. Then we also have the criminal laws as well, the IPC, the CRPC and the Evidence Act, which is now replaced with the BNS, BNSS as well. So in the going forward, if these laws are anyways implemented, they have to be debated, deliberated and ultimately discussed. The stakeholder approach should also be taken into picture. For example, we have the BNS, that is the Bharatiya Nyaya Samhita. It is replacing the Indian Penal Code. One of the sections to do with the BNS happens to be the hit and run rule. So the hit and run rule will basically impact the drivers who work in the motor vehicles, even despite not wanting to kill them. If there is negligent driving that has taken place, and penalty was about 10 years was imposed, but these people started going against this particular law, which means they also wanted to not accept this particular law. Why? That is because they felt that a stakeholder approach should have been taken. So their consensus should have been taken. They should have been discussed as well whenever the law was being drafted. So in this particular backdrop, whenever a law is also being drafted, we have to discuss it, says the author. So the author says that whenever you are coming up with a law which is going to have a significant impact, discuss, deliberate and also come up with a consensus based law is what the author says. The other aspect that the author also brings into picture is with respect to laws which are not right and also reactive approaches to law. What do we mean by reactive approaches to law? Let's say, for example, in Hyderabad, we have one instance. I'll link two instances here. There was a rape that occurred in Delhi. There was a rape that occurred in Hyderabad. What happened in Delhi? It was a heinous offense. Yes, it is a heinous offense, and these people should be immediately thrown behind bars, and capital punishment should also be imposed on such individuals. Why? Because this happened to be the heinous of the heinous offenses and a rape that was committed on a girl. So in Delhi, when that particular incident happened, this was expedited, this entire process was expedited, and what we had is a process of law, due process of law. Ultimately, evidence stage, everything was given. They had an advocate as well, and ultimately they were imposed with death penalty. That is one part. There was another similar instance that happened in Hyderabad where a girl was gang raped and ultimately she was charged to death. She was burned. Yes, this is an equivalent one where a girl was raped and ultimately she was killed. But what happened in this particular case? The due process was not followed, and these individuals who committed the crime were killed. They were encountered by the police officers. What is the difference between these two instances? In this particular process, death penalty was imposed by the court, which ultimately also meant that the due process of law was followed in the first instance. In the second instance, yes, they might have committed it, but what if the police officers did not know who committed this particular crime, brought in another people and just pushed in as these victims or the accused in this particular case? So there was no due process of law. Maybe these people were just pushed in by the police officer. We do not know. That was the allegation that was made against the police officers. If at all they were supposed to have been hanged, it was the due process that was supposed to have been followed. So what is reactive approach? Just because they have to convince a certain section of the people in the society, a reactive approach comes into picture where these people are encountered. So there is no due process that is followed. So we have the law, these laws are not followed, there is encounter approach, there is reactive approach, and there is bulldozer politics as well, bulldozer policing as well. These people whose houses have been thrown apart, these people should have been given a voice, they should have been heard, they should have been heard in the court of law, and ultimately if at all they violated the law will take its course. Bulldozing and reactive politics and policing should not happen, says the author. So the author also brings into picture two instances where the shooting of a young car mechanic of the Algerian descent led to large-scale violence in several cities in France, custodial torture and civilian deaths in the course of security force action and inquiry after the ambush of army vehicles in Puch district as well. These are instances where there was violation of rule of law. So the rule of law should be uniformity, predictability and certainty, and model looks for quick and reactive ways for doing repressive justice should not be taken up, says the author. So there is this famous dialogue that there is law, there is justice. What we have to do is bridge the difference between the law and justice. Justice is equivalent to dharma. What is dharma? What is right? What is right in that particular instance is dharma. But what is law? Despite it is right or wrong, in this case what the law says should be followed. For example, a person might have given a money to another person, hypothetical example that I am giving you, and this person should have ideally asked for the money within a period of 3 years. So there is a cause of action that has arrived. So ideally in money recovery suits or check bounce cases and all these cases, they have to ask money within 3 years. What does the law prescribe? So you, being a person who has given the money to another person, you as the victim of this particular issue should have sought for the money within 3 years from the day you have given the money. If at all he says he is not giving the money back, you knew for the fact that within a period of 3 years you have to apply for a case. So what does the law say? The law says you have to apply it within 3 years. But what is justice? Justice is making sure that despite this person not filing a case within 3 years, looking by the clear picture, not going by the technical procedures, providing justice to ensure that this person gets back the money despite he not following the procedure is one of the aspects of justice. So I am giving you an example. Do not write it. This is to simplify the process for you. So what is difference between law and justice? Law is the written act. What is justice? Justice is beyond law. It is about the authenticity of that particular issue and ultimately ensure that dharma or justice is provided to that particular individual. The righteousness comes into the picture, and we do not just stick to the law, the procedural side of the law. We go by the tenets of justice is what is this article all about. Now let's look into the next article. This article says unlawful remission. What are we speaking about? This article here is speaking about remission. Let me simplify this process so that you understand what is this article all about. There were a group of people. These group of people were thrown behind bars. Why? Because an allegation that was put on them was that they had raped a few women, and these women ultimately succumbed to the rape, a heinous activity, and once it was proved, these people were convicted. So initially it was an allegation that a group of people had raped women, and these women go to the court of law, and once it was proved, these individuals who raped them were convicted. What happened? This happened in the state of Gujarat. So when it happens in the state of Gujarat, somewhere they felt that they can come under the influence of the local politics, or the judges may not deliver justice to these rape victims. In this particular backdrop, the case was moved to the state of Maharashtra. So what happened? In the state of Maharashtra, this entire proceedings happened, and ultimately these people were imposed with life imprisonment. What is life imprisonment? Life imprisonment basically means that a person will be imprisoned for the rest of his life, which means that he will not be released into the society, and he has to live in his life for the rest of his life. So he has to live in the prison for the rest of his life. So because these people had raped women, because they could come under the influence of the local politics as well as judges, this case was transferred to the state of Maharashtra. So it is the state of Maharashtra and its judges, that is the sessions court as well as the high court, which is looking into this particular case. So it convicts these individuals and throws behind bars and also gives them life imprisonment. But where are these people from? They are from the state of Gujarat. So they are thrown behind bars in the state of Gujarat. But Gujarat government also has the power under CRPC to basically remit these individuals, which means they have the power to ensure that these people given the remission. So if at all these people after 14 years, they have good character, they have showcased that they have very good character over a period of time, they have been assisting the police officers, they have changed over a period of time, because this happens to be a progressive one. If at all that is done, this life imprisonment can be turned into remission after 14 years of their imprisonment. So what did the Gujarat government do? The government has the powers to ensure that this life imprisonment is converted into remission, and ultimately these people are left into the society. What did the Gujarat government do? The Gujarat government did offer this remission, and they were released from the jail as well. This becomes the question before the Supreme Court. Why? That is because yes, the state governments have the power to ensure that it is remitted and there is remission that happens if at all there is life imprisonment. But the question that is being asked is, does Gujarat government have the power? Why? That is because this entire proceedings happened in the state of Maharashtra. They were convicted in the state of Maharashtra. Every procedure was conducted in the state of Maharashtra. If at all remission has to be done, it has to be done by the state government of Maharashtra and not by the state government of Gujarat. So this was a question that was asked before the Supreme Court of India. So the Supreme Court of India looked into this entire premise and has now delivered a judgment saying that if at all there is a government which can conduct this activity of remission, it is not the state government of Gujarat, but it has to be the state government of Maharashtra. So if remission has to be taken up because these people have changed, it is not the state government of Maharashtra which can do it. These people will have to apply with the state of Maharashtra. The state of Maharashtra will decide whether these people have to be acquitted or not, whether they have to be given remission or not. So whatever has been done by the government of Gujarat for now, where remission has been done, this is illegal, this is unconstitutional, this is not allowed in the due process of law, and then the Supreme Court has cancelled it. So the people who were out were also asking a question, at least allow us to be out on bail, on the bail concept. So the Supreme Court has said, you are convicted, you cannot be released on bail for now. So go back to the court, go back to the prison, and ultimately ensure that you file a fresh one before the Maharashtra government. If at all the Maharashtra government allows you to do so, then you may be given the power for the remission, says the Supreme Court. So the point of this entire article is which government gives the remission and which court has decided this entire exercise. If it was the state high court of Gujarat which had decided it, then there would be all possibility that the government of Gujarat had the right to do so. But since it was decided by the court in Maharashtra, only the Maharashtra government would be able to decide. So you apply these petitions before the Maharashtra government, and if at all they accept it, then in all likelihood you can be allowed to do so, is what is this article all about. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best. If you're liking these initiatives, please hit on the like button, subscribe to our YouTube channel, and also share it with your fellow aspirants as well. Thank you.